Right. Paul, hi. So if you just say a bit more about your background and so on. That's great.
Okay. I mean, it's slightly unnerving. So I'm used to public speaking, but not so much being videoed. But it's actually more unnerving than being in the High Court. I have been a barrister for the last 8 years doing civil law, and in the last couple of years, I've started to combine it with my long-held sort of activism and love for nature. And that started off in Sheffield, representing the tree protesters there and seeking to stop or minimise the injunction that the council was trying to get against the protesters. And from that experience, I've sort of put myself out there as wanting to do law in protection of the natural world. And obviously at the moment, the other key thing other than trees that I'm getting involved in as a result is fracking related things, because that is the sort of one of the main environmental issues that we face in the UK at the moment. So I'm actually in the High Court next week for 3 days, resisting an injunction application by iGas in relation to a number of sites. And in some ways, actually, I was up till 1 a.m. in the morning last night doing the skeleton argument for that case. And it actually brings me on a bit to the idea that is being put forward about trying to protect the commons, the air that we share, the water that we share, all those kind of things. Because as I was writing it, for me, the ideas that I was writing made total sense, i.e. that people's economic interests and property right interests as they stand must be balanced against the interests of the wider community in not destroying our planet through climate change, in not destroying our water table, etc., etc. But actually, legally, I was really struggling to make those arguments, and I've made them. And to be honest, some of the arguments I made in my skeleton argument yesterday, barristers do not normally make them. They are very, if I can put it, out there. But I think it's important to start making them. But actually, I recognise that they are going to probably get very short shrift in the High Court next week, because quite simply, the current legal system does not recognise any other sort of counterweight to this private property, private law rights, money rights. And the only counter they do give, I suppose, is human rights considerations. But that's obviously different. That's about the rights to protest in relation to something. But actually, as you will all know and I'm sure feel, there is actually a more important counterweight than people's rights to protest, and that is the rights of the natural world and the rights of all of us to have those commons that we rely on unsullied. And that is just not an argument, and judges just don't even get it. They look at you as if you're mad. And what an interesting juncture we've reached in our law and our society when you're looked at as mad for saying that humans, we need to avoid catastrophic climate change. We need to have clean water to drink, and we need to have clean air to breathe, and we need to have the trees that produce that air. To me,
it's a very worthwhile thing that you're doing, and I think it's got to start somewhere.
Exactly. And for me, I'm increasingly seeing it as a multi-pronged approach. Actually, a little bit like what you were talking about earlier, when some of you were saying it was the direct action that did it. Some of you were saying it was the planning stuff. Some of you were saying it was the local democracy stuff. And actually, it's all of it. It's all of it. And at the moment, we need to take all those approaches. So actually, my approach next week in the High Court is a multi-pronged approach. So we're obviously doing the legal stuff, and I've tried to put together as best I can legal arguments that make our case. But I've also made a number of kind of what I would describe more political, environmental arguments, which will get probably shouted down quite quickly. But I've got a journalist coming to cover those. And also we are going to be hopefully doing some videos outside court to sort of raise the issues. And I've also contacted Jenny Jones in the House of Lords to try, and she wants a briefing paper on the use of injunction in cases. So it's this sort of multi-pronged approach on stuff that I think is quite is quite interesting, and where we're arguing with something that the current legal system just doesn't recognise, that is the way that we sort of begin to shift that. And so that sort of, I guess, brings me on to this idea of protecting the commons and whether that can be legally recognised. And as a barrister, if you were to get a barrister's opinions now and say, is there will the courts currently do the courts currently recognise a legal right in the commons, in terms of air, water, and that kind of thing? They don't. So if you were to try and use that as a kind of slam dunk defence against a specific fracking operation, by itself it probably wouldn't be enough. But nonetheless, I think it's a very valuable thing to start deploying in conjunction with other methods. So getting it out there in the courts, whilst also getting it out there in the media and in activist circles, I think that is where you begin to have this effect. And the same works with trees as well. Like, tree protection in this country is absolutely shocking, but just campaigning alone won't solve it, and nor will going through the law. You need to follow all these approaches. And so, for instance, what happened in Sheffield was they have largely probably won. They're still doing negotiations right now. But actually, as a lawyer, I lost every single case. Every single case. We lost every single one, and the council got the one of the harshest injunctions ever awarded. But through very savvy campaigning and activism, every single victory that the council gained in court put them back in the overall struggle, because people saw how manifestly unfair it was and saw how harsh and awful the council were being, and that brought more people out onto the streets until it became literally impossible to enforce the law that they wanted to on the streets, because there were 10,000 middle-class people who didn't want it to be enforced on their streets. And that it's that sort of multi-pronged approach that I think works. And so for me, I'm as a lawyer and an activist, I sort of fall between those two stools and recognise that they both have value. And I'm not one of these people that says the law solves it all. And I get people regularly emailing me saying, "Oh, I've got this tree and you can use the law to save it." I'm like, I probably can't actually, and I also probably can't stop fracking just through a purely, I found a legal case from the 19th century that it stops it. But nor do I believe that we completely ignore it and just go into activism. It's this having both sides and using them both, and letting one benefit from the other, I guess. And there is, I think, especially in this campaign, potential value in starting to put forward these legal arguments about the commons, even if they are rejected, because by getting them out there and having them heard in courts, I think that has a value that can then be picked up on in other cases. Like, for instance, like I'm going to be making arguments next week in the injunction case that aren't normally made. Like, people normally stick to very much legalistic stuff, but I'm going to be saying, I'm going to be looking at the cost of injunctions and basically saying that they are creating a parallel system of law for the rich. Which they are. The judge will not like that, and it will not win me the case. But
then it's said, though, you know.
Say again?
It's saying it. It's getting.
It's said, and it's out there, and people might then start to think about it a little bit more. That's the whole point. Exactly. So,
and you also use your opponent's strengths against them. So me and my client are very much the underdog next week. My opponent is a top QC from the top set in London, and who has a junior working who's my level of cool. So it's two people and a team of city solicitors. So I was there sort of in the early hours of the morning trying to put a skeleton argument together that is, a third of the length of theirs, because I just don't have the resources to do it. But for instance, it's not about what happens in court. There's also the narrative to control. And in this case, I want to create a very clear narrative about this use of private law for the rich, by the rich, and the corruption of the legal, probably shouldn't use the word corruption in the video, the co-option of the legal profession into that. And so one of the arguments I'm going to be making is that when I see their cost schedule, I don't know what it's going to be, but it is going to probably be outrageous to any ordinary person. And to start publicising that and use that to gain ordinary people towards our cause, because they will recognise that level of cost is just grossly unfair. And like, for instance, one way of doing that when it comes to these submissions is to, instead of, we always just say whether they're reasonable, it's always compared to other lawyers, but I'm going to hopefully break down their figures and compare it to what a nurse gets paid, or a doctor, or a soldier, or even other professionals. And it will, I imagine, come out at such a large figure that people will be actually quite outraged by it. The QC in the Sheffield tree injunction case got paid £25,000 for 2 days' work. Ordinary people think that's disgusting.
Nice.
Use all the tools in the toolbox.
Exactly. And so that is where I see the value of looking into this idea of the commons. And it wouldn't just, I think, go into fracking stuff. It would go into all aspects of environmental protest and law. And as I say, the key, come back to what I began with, the key factor is at the moment, the legal system just doesn't recognise any counterbalancing issue when it comes to property rights and money, other than a small amount of free speech, but that's mostly dispensable. We need to start establishing that counterbalance, which is it can be expressed, I suppose, as the rights of nature, wild law. Me and Mothiur went to a conference in September about that, or it can be expressed as this right in the commons. And actually, the two are sort of separate but sort of interlinked. So there is nature has rights in its own right to not be destroyed, but actually because we actually truthfully rely on nature so much, we have important rights in that not being destroyed as well. And it's the failure of the law to currently recognise that is frankly causing all the problems. But it's not a failure which is impossible to change. It will take time, and at first they will think you're mad for saying it. But before the 18th century, there was no such thing as companies. If you were to try and explain the concept of a company to someone in the 15th century, they'd look at you like you were mad. Like you're going to give rights like a human to like this fictional entity that will then become the most powerful things on earth, more powerful in fact than things that actually exist. But it happened. And also crucially as well, I mean, to get into the slightly more political elements of this is one of the change is going to happen. A change is going to happen, and either the current system will destroy itself and probably us, or we will recognise this idea of rights of nature, rights in the commons. Because unless we do, the destruction of money and of property rights and of private companies and rich individuals will push us towards. Push the destruction towards our civilization, I suppose. That was the more political element of that.
I like this. Just when you were mentioning about the way in which acting for the litigants, for the defendants in the tree cases, led to civil society uprising against it because of the injustice. And we were talking a lot about injustice, and the more it's almost as if even if the law is not on our side, what is on our side is civil society. And so that the more that we show that the system isn't working, the more that we collect that energy, that energy for change.
And that at the end of the day is going to be what pushes the thing over to our way of thinking.
Yeah, exactly. And also crucially, I think to me it extends beyond the actual individual campaigns, and each one acts as a recruiting tool to get people to change their views on the world. There are now thousands of people in Sheffield who care about the environment that weren't against it, but didn't really feel it that much before the Sheffield Tree campaign. And actually, these local campaigns about fracking and about trees are really good recruiting tools to the wider issue, which is the environmental destruction caused by the way that our system is currently set up. What are your thoughts? Anyone have any thoughts there on that?
From my point of view, it's really good to have met you in this way and got an outline of how you think, because you're thinking, I would say, exactly along the same lines as we all are. So it's encouraging to have someone like you out there. And we'll do whatever we can.
I should warn you as well, by the way, that the way that I'm agreeing in terms of the way my thinking works, that you find it interesting and you appreciate, is to many lawyers like completely mad.
There are a bunch of lawyers, mad lawyers as well.
You're among friends.
Great. Yeah, and to say that many lawyers, they look completely blankly when you even think about trying to these broader issues about things. The law says this, and that's what it is, and that's what I will do in my case. And I think differently. For instance, again, this came up in the Sheffield thing. I was representing some injunction campaigners, and another lawyer was representing other ones. And his arguments were very legalistic and went down much better with the judge. Actually, I got quite short shrift for a lot of my arguments, but also mine helped in a wider sense. So I just got away with trying to cross-examine council officials as much as possible about the tree felling programme, which none of the questions were really related to the injunction, and actually didn't really, if anything, probably hindered my client getting off the contempt charges slightly. He told me in advance he was happy with that. And then each answer that these witnesses from the council gave under oath, everyone was scribbling down straight on Twitter, straight in the local press, blah, 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 and so there was a long-term issue of, my client went down for contempt of court. I mean, to be fair, he did do the contempt and put it on Facebook. So it was a tough brief. But in that case, a lot of lawyers would just go, well, let's just try and get in the lowest sentence possible, mitigate this. And he was like, no, let's use this to our political advantage, because we have all these witnesses for the council in the witness stand under oath. Let's get some answers out of them. Let's put them under pressure. Similarly, in the injunction hearing next week, they've had to put in witness statements to show all the protest activities. So I'm going to be just trying to get away with as much stuff as possible to ask questions about, for instance, collusion between the police and the fracking companies over protest, and how it's policed. Not maybe strictly relevant, but very interesting to get.
Am I right in thinking? I don't know whether you're free to say this or not. Am I right in thinking that you're working with Ian Crane next week?
I am, yes, and I should predicate this with the fact that I know he is a controversial figure in the anti-fracking world, and I've heard that from a number of sources. He asked me to represent him, and I heard the controversy. So I went to a couple of people in the fracking world who I know are well respected and who are trusted, and asked sort of what their opinion was, and they said he's a very difficult person who's rubbed a lot of people up the wrong way, but his heart is ultimately in the right place in terms of anti-fracking. So and my attitude with it is as well is that actually any chance to put the fracking companies under pressure legally, I am willing to take.
Yeah,
and
I
actually
didn't raise that because.
No, I just say that because I've previously, when I've told other people in other fracking sites about working with him, I've got these sort of stares of disapproval because I think there's been some interpersonal politics.
He's helped us enormously in Ryedale.
Okay, great.
Most of us hold him in very high regard. So.
Great, that's really good to hear. Thank you, because it's really hard when you're entering in from outside. Because obviously I've only been involved in sort of 6 months or so. When you're entering from outside the scene, to know about all the kind of the personal politics aspects of these things, and
I'm sure you'll do the right thing in terms of you'll assess Ian Crane as you find him. Personally, I back up what Sue said. I've got a lot of respect for that. The reason I raised it is because you're dealing with someone who's got a really thorough knowledge of the whole subject. He's got a lot of experience and evidence as well.
We also share an important view, which is that he is very much into the wider issue here, which I'm also into, about the use of judge-made law on behalf of the rich to subvert democracy.
Yeah, absolutely.
And we're both really into that idea, and the judges will probably go ahead and make the order, but we're both very much into the idea that we don't care if we lose. Obviously, we want to win next week, but we understand that there is a value in standing up and saying, actually, we're not going to let you just get away with this and just do this without any challenge. We're going to stick as much of it as possible, make you stand up, make you incur a lot of costs, if you want to do this, and also publicise all our arguments in the media, so we can start having a wider conversation about why we are allowing rich people and rich companies to get their own private criminal law that other people can't afford.
I think the point you made earlier on about other barristers think you're mad talking the way that you're talking. I personally think it's a bit similar with Ian Crane. A lot of people think he's mad because of what he says and what he does.
Interesting.
But actually, he's most of the time he's flagging up real issues.
Yeah.
And he's ahead of the game.
Yeah. That's interesting to hear. Okay.
And it's finding forums to speak in as well, because just when you're saying about that strategy of being in the court to get them people to be under oath when they're responding. Because I was at the meeting with the Royal Society and the All Parliamentary Group, APPG, and they're saying in that forum not everybody has to come forward, and so they can ask people to come forward or committees, but they might not come forward. Whereas in a court, you've got a much what people are saying there is under a duty, and that's a different forum that can get different kinds of answers.
Mm-hmm. Mm-hmm. And it's even down to stuff like. It might be hard to. Oh, hello, you still there? Yeah.
Yeah, we still.
At the moment, how do you estimate the cost to bring in a fracking injunction? Because it's one of my arguments, for instance, that actually, in practical terms, the ability to get a fracking remedy, an injunction remedy like this, is probably limited to less than 5% of the population, maybe even less than that, maybe 2% of the population, something like that, in terms of the sheer costs of doing it. But of course, how do you estimate the costs of getting an injunctive relief in a fracking case? Well, luckily they have to serve a cost schedule, and they have to sign their cost schedule saying that those costs are reasonably and proportionately and necessarily incurred to bring the injunction hearing. So they have themselves signed off that whatever ludicrous cost schedule they're going to present in a couple of days' time is what it costs. And then you can turn around and say, well, if this is what it genuinely costs to get this remedy, then how is that fair when the majority of people can't get that remedy just through the sheer practicality of the cost?
Great.
And especially where it's preventing conduct, which is the bit we're really going for is the bit about on preventing protests on the highway, because of course that's already prevented by the obstruction of the highway under the Highways Act. And so the argument is, if you don't like what the punishment for that is, which is a fine, then your solution in a democratic society is to go to Parliament and lobby to get the rules changed for everyone so that you can imprison someone for obstruction of the highway. Your remedy, I would argue, is not to say, well, here's $100,000 to some city law firm, get me my own private criminal law that other people in this society can't get. And I think it's very dangerous to the rule of law and the acceptance of the rule of law by the majority of people, if you like, governing by consent, when we start having that kind of two-stream dual class criminal law.
Paul, we've got to leave quite soon, but we've got Nick here, Nick Cohen, who's an expert in climate, a scientist.
Hello.
Slightly different question. It's about.
Sorry, you're a bit quiet. Could you?
What you were saying about the judges not wanting to hear certain arguments about common good, about public good, and I mean I think it's a sort of practical reductio ad absurdum in the whole thing, because if they say, well, we're always just here to enact the letter of the law, whatever the law says, with the climate change, is that it can have such an impact on society that it's simply no longer capable of continuing as a civilized society. And we're surprisingly not all that far away from that, actually, in terms of numbers of years. And
Yeah. I know I haven't got much time. I do want to tell you, I'm very proud in the first opening paragraphs in my skeleton argument for the case. I did put this, which is I wrote about the IPCC report. We've got 12 years to effectively decarbonise our society to a great degree. There are hundreds of billions of pounds of carbon-based assets, which those who own them have a personal incentive to get as much out of as possible before they can't use them anymore. And the general populace have an incentive for them not to do that. And so you're going to expect an increase in protests and direct action. So I said, it is inevitable that there is going to be a growth in the use of these kind of injunctions. They're going to try and use as much money as possible to try and get the most restrictive laws they can under injunctions to stop people who are trying to challenge their, what I would regard as anti-social, anti-commons behaviour. And I put that in the I put that as the context. I don't think anyone's ever made an opening like that in the skeleton before, and I don't know what the judge is going to make of it. But actually, again, I think it's important to say that is the truth of it. There are people who have millions and billions of pounds to be made out of the destruction of our world, and they will stop at nothing to try and clamp down on the protests which are going to arise as people wake up to the fact that their behaviour is destructive. And injunctions are going to be used more and more creatively by ever more highly paid lawyers unless someone starts to stop them.
So I'm really concerned about the fact that judges don't see the big picture, and they don't see what's coming, and they don't see. There was actually an absurd bit for me is that ultimately they wouldn't even be able to operate as judges because they won't be able to judge over, and yet they're not even to begin to look at the inconsistencies in their position, in the world that's really.
I should say as well, I've been railing a little bit against judges. I genuinely don't go towards this argument that some in the movement make that our judges are corrupt or that they are bent or anything like that. I think actually genuinely English judges are upstanding, completely honest, almost to a T, people who see it as almost like a religious duty to apply the law fairly. But the problem is, as I keep saying, that the law at the moment doesn't recognise this counterbalance. So when they're fairly applying the law as it stands, it will inevitably lead to decisions which are environmentally destructive and ultimately actually destructive of the world that they and their own children depend on. You know. So that is perhaps why I suppose why we've got to start making the arguments to them that there is the potential to recognise these commons.
That's and that's a good point. We need to move, but that's the counterbalance that this idea of the commons, the trust doctrine, is what we're trying to create, and hopefully we can at the next meeting see whether we want to. If you want to take that forward.
Yeah.
Great. That's a brilliant introduction.
And I hope I've got across the fact that I don't think necessarily that the public trust doctrine is going to be an immediate trump card that will win us the. But I do think it's a very important tactic, along with political pressure and activism, in winning the war.
Yeah. Thanks very much.
It's been really lovely to chat to you all, and it's as ever, it's a real joy. Sometimes I feel a bit isolated in the world that I'm in, with the beliefs that I hold. It's really lovely just to come across lots of ordinary people who care and who are doing something about it. So thank you all for everything you do.
Are you on netball covering what you're doing next week?
So I can't hear you. Say that again.
Are netball going to be there next week? Because the stuff that you're going to be asking about the police and collusion, they'll be very interested in.